Hi, everybody. Thanks for tuning in. We appreciate it. It's good to be with you again today. Our guest on this podcast is Mr. Danny Villazon, an attorney out of Orlando. Now, Danny represents a lot of appraisers and real estate brokers for that matter, but we're talking primarily appraisers before the Florida Real Estate Appraisal Board, a board known for its fairness, but for wielding a pretty big hammer. So Danny is in the position to describe to appraisers what's going on relative to what gets an appraiser in front of a board, what penalties are assessed, etc. And Danny, that's exactly what we're going to talk about. But before we get into the business part of it, how are you?
Good. I'm doing great. Keeping busy.
That's wonderful in one sense and terrible in another sense.
Right. It's good
What,
for me, not so much for the
Yeah, it's
appraisers.
good for you. Not so much for the people you represent, but it's good to be. It's good that you're busy. Danny, before we get started, if anybody were to need to get in touch with you relative to your services, how would they do so?
I have a website. It's called FREC, F-R-E-C, attorney.com, or they're more than welcome to call my office at 407-483-0041 or email me at info@frecattorney.com.
FREC, means Florida Real Estate Commission.
Yeah. I
Attorney,
have one pre-app attorney, but I don't use it that much, so I just stick with the FREC attorney.
and whatever works. So
Yeah.
FREC is FREC. Are they all capitalized? Does that make any difference?
Doesn't make a
Okay.
difference.
So it's FRECattorney.com. Okay, Danny, good. Thank you. We appreciate that.
Sure.
Now, you and I have spoken before this podcast on various things,
Mhm.
but because of your situation, because you work with other appraisers, because you work with the Florida Real Estate Appraisal Board, because you know the statutes in Florida, because you're generally familiar with USPAP, let's start out by talking about what gets an appraiser in trouble with his or her state board. Are there any? Let's talk about the big three, assuming there were only three reasons. But in your experience, what are the big three reasons that appraisers end up having to spend a less than pleasant afternoon with their state appraisal board?
The main thing, my experience, I've been seeing that the department focuses on is work file compliance. What I see a lot is even though sometimes we get some silly complaints from a seller who's not happy with the value and the complaint has no merit, the department or in FreeApp sees it as an opportunity to do a USPAP compliance inspection of the appraiser's work product. And the biggest thing I see that's always getting them in trouble is the work file issue, that they're not complying with the record keeping rule in regard to the work file. Specifically, what usually happens is a lot of appraisers tell me they make adjustments just because they know the market and this is what they've always done. But they're required, according to the appraisal board, is to have some documentation in their work file to support the adjustments. For example, paired sales or something like that. That to me has been the biggest issue I've seen, and the majority of my cases deal with work file compliance. Another issue that came up a lot, especially during the COVID time, was people signing the appraisal report that they physically inspected the subject property and in fact sent a trainee or someone else out there. And they didn't indicate, the trainee didn't sign the appraisal report. We had a lot of those. Those are kind of starting to die down, but that's also a big issue we have with the appraisal board. Those are the most common cases I see before the appraisal board.
Okay, let's talk about the first one, the work file. In other words, what the board is saying is like high school algebra. You got to show your work. Is
Yeah.
half the answers are in the back of the book. So you've got to say, well, yeah, my GLA is $47.50 a square foot or GLA adjustment, and here's how I got it. Now, there are various ways to get there. In your experience, have you found that there is one protocol for arriving at an adjustment that the state favors over another? In other words, does the state want to see paired sales, or is the state quite happy to see the extraction of a GLA adjustment from improved sales? What floats the board's boat? What makes them say, "Oh, okay, that's good enough. Let's move on to the next one."
Honestly, I don't know which method they prefer. They just want to see something. Usually, if you have, most of my clients, they say they did it by paired sales and are able to show how they came about that. But as long as you have something, the problem I run into is, you know, I get the answer, it's just my experience. I just know what it costs. And that's the wrong answer. You have to have something. I've seen some new programs. I don't know. I'm not familiar with the different programs out there, but some people have certain programs that do paired sales analysis for them. I think it's called Redstone or something like that. And as long as they have something in the work file, it's usually not a problem. It's just when they just give the stock answer, oh, I just, based on experience and my knowledge of the market, that's not going to work. But I don't know which is their favorite method of determining how adjustments are made.
Okay, so the favored method on how adjustments shouldn't be made is my 30 years experience.
Correct.
Okay.
But that's just the way I've always done it.
Yeah. Oh, yeah, that typically doesn't fly. All
Yeah,
right. Okay. Now, relative to this, that appraisers are supposed to support their adjustments in whatever manner they find.
right,
It's not new. I mean, this is not something that came out with 2024 USPAP. This is the way it's always been. But yet, as you say, you keep going back before the Florida board because it keeps charging appraisers with not supporting their adjustments.
right,
Despite the fact that this is not new, despite the fact that this is not a secret, appraisers keep depending on their 30 years experience. Now, look into your case files, peer into your crystal ball, into the foggy mists of the past. Why do you think, and I'm obviously this is purely your opinion, why do you think that appraisers keep making these same mistakes when it's so blatantly obvious they shouldn't?
I think they're under enormous pressure to get the appraisals out as quickly as possible. The fees keep on being reduced. And there comes a point in time economically where, the perfect USPAP compliant appraisal report will require at least 20, 25 hours of work for the minimal fee you get. So appraisers, unfortunately sometimes take shortcuts, especially in something obvious like and they've been doing this for so long, what a extra bathroom is worth. So I think they figure just, this is what I do. I've done it for years. I've never got called out on it. And they don't get the paired sales to support the bathroom adjustment or something like that. I think that's the biggest issue. I think some of them, because they're such in a rush, they don't print out and get all the documents they use to support their appraisal report and the numbers they put in the appraisal report, and just hope they don't get caught and or have to reproduce them because um, the investigators are trained to look at when the things were printed out. They check to make sure that you did it at the same time you did the appraisal report. So I think it's just pressure, 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 pressure on the appraisers, and it's only getting worse with all these uh, everyone taking a bite of their fee and reduced, 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 and the time pressure to get things done.
Okay, let's look a little bit more deeply in this. Now, you and I were involved in a case here in Florida back in January, February, whenever it was.
Mhm.
And the appraiser was asked to turn in his work file. Obviously, the work file is supposed to contain a copy of the appraisal report. Or USPAP says, if it isn't in your work file, if you can reference it, that's
Right,
perfectly
right,
okay. However, in this particular case, the appraiser went to the website, the lender's website where the appraiser was stored, or excuse me, where the appraisal was stored, but couldn't download it because of a computer glitch. So the
right.
appraiser said, in so many words, State of Florida, I'll be happy to get this to you as soon as the computer unglitches and I can get a copy of it,
Hmm.
which on its face looks like a reasonable excuse. But the state of Florida said, it's got to be in your work file. It's got to be in paper, in your work file, between the wings of a manila folder, and it has to be there literally from the instant you sign it forward forever and ever. Hallelujah, amen. And this appraiser was hit with a rather substantial penalty. So, w-
Yeah,
w- go
a
ahead.
lot of problems with that whole case. First, the administrative law judges that hear their cases are not appraisers. And this was a super technical point. As you know, in the pursuant to the record keeping rule, you're supposed to have copies of all the appraisal reports you submitted to the intended user. Unfortunately, my client, because of a computer glitch, could not get one of the original, I believe it was the original report, to the investigator when he asked for it, and ultimately got it from the intended user. And as a result of that, the judge felt he wasn't in compliance with the work file rule. I think this case should have been resolved from the very beginning. Uh, I'm, I'm not self-promoting, but if he would have had counsel from the beginning, I don't know if it would have moved to a formal case, because this was just a misunderstanding. There was no consumer harm. He had ultimately had the report. It was really the original report just had a typo, and the AMC told him to correct the typo. He did and sent the second report, but he didn't keep the first report. He lost it. It got caught up in the system. And on that little technicality, they dinged him as a violation of the record keeping rule. So sometimes it's beneficial when you get that initial complaint to get someone involved to represent you, because it can be shut down at that time, because the appraisal board, the attorneys have the option of closing a case with a letter of guidance, which remains confidential. It's the tantamount to a dismissal. So it's very important not to ignore something, to get on it from the very beginning. And I always tell my clients, I'm going to do everything I can to keep this thing confidential, to explain to the attorney what happened, because this case to me was went way out of control. I got into it late after the administrative complaint already been filed, and they would just refuse to drop it. They charged him with a lot of other things, and all those things were dismissed. They only caught him in that little technical thing, because the judge basically didn't believe him, I guess, as far as credibility is concerned, that he did have it, and it was just a computer glitch. Very sad case. It's very disappointing, because I don't think they proved their case, but the judges sometimes just feel they have to give the state something.
Yeah. Okay. All right. Yeah, I've seen that before.
Yeah.
Okay. Um, uh, a, a tangential question, but one that's related to what we've been talking about: appraiser education. Given what you now, granted, you're an attorney, you've been to law school, et cetera, et cetera, et cetera, and I'm not trying to compare what appraisers do with what you do. Please don't take it that way. But given the, do you think appraisers are properly educated deeply enough to do well what they're really supposed to do? Or is our education more oriented toward filling out forms and getting the report out the door?
Yeah, I'm not real familiar with the appraisal education. I do see it a lot of form filling out. I don't know how much the instructors go into the actual theories and why you do these type of things, and why it's important to have support in your work file. I think some appraisers, especially the newer ones, have just gotten into the habit of just filling the box and are really not putting any thought into the process. They're more just, this is what it says, not really knowing, understanding the theory of how they came about this adjustment, or able to articulate how they came up with this specific number and how they came up with the adjustment. I always tell my clients, we won't be in trouble if you can explain to the judge or to the investigator how you derived the numbers that you derived. You didn't just pull them out of thin air. That's always the big issues. How you selected your comparables. You have to have some methodology, some reason to your madness, I say, as how you came about doing what you did. That to me is the most important thing. I haven't been to an appraisal class. I know there's a lot of courses out there, but I just don't know the quality of the classes and what they're teaching right now.
Okay. From a standpoint of, you say, especially some of the younger ones are oriented toward filling the box rather than justifying why they put that answer in the
Mhm.
box. This gets back to critical thinking. And a cynical definition of critical thinking is doubt everything, therefore prove everything.
Hmm.
Now, obviously, we have to make some assumptions. We have to assume that when we get an appraisal order, the owner of the property has good and merchantable title, unless we're told otherwise.
Right,
We have to assume that the data we get out of MLS are correct. We
right,
have to assume that the sun's going to come up in the morning and there's going to be another day.
right.
Okay, we get to make those assumptions. But what about assumptions? For example, one of my favorite assumptions is an appraiser once told me that he never made a GLA adjustment greater than $50 a square foot and less than $30 a square foot. And I said, okay, why? And he said, well, because that's what works. I
Yeah.
said, well, okay, what if it doesn't work? Uh,
That's the
well,
exact problem I see, is that that's just the way I've done it. And rather than saying, this is why I did it. This is and I don't think you have to have the calculations in your work file, but you need to be able to articulate how you came up with that number and the fact, and I've had people tell me, it's the way I've always done it. That doesn't fly. That gets you in trouble.
okay. Let's talk about the new ROV, reconsideration of value process.
Yeah.
And you're going to be getting a lot of work from that.
Oh, it's insane. I mean, I don't know what Fannie Mae's doing, but I've been getting a case to two cases a week on Fannie Mae complaints. It's just ridiculous. And the interesting thing is their complaint is bullet points. Didn't like the comparables, improper adjustments, just general bullet points. And honestly, they don't really cooperate with the department in regard to helping them support the complaint. So what the investigators have been doing is going to the AMC and getting a copy of the file, and in there, there's usually a letter indicating why there's a buyback on the property that really goes into detail with the problems with the appraisal report.
So, in other words, uh, given the fact that Fannie Mae turns in merely those bullet points,
Yes,
then you, as the counsel, and obviously, you've got the clock turned on. So you, as the council, have to do a whole lot of what really amounts to unnecessary work, therefore charging the appraiser for your time when it would be a whole lot easier if Fannie would say, you used the wrong comps. Here are the ones we would have recommended you use had you asked us. Uh,
yes.
Okay. So, while in one sense that's a benefit to you and people like me, but in another sense, I've always thought it was unfair to the appraiser. Is that an opinion with which you'd agree?
Absolutely. I mean, if they're going to file a complaint against someone and threaten their livelihood, they should have support for their allegations and work with the department to support those allegations. They've never come as a witness. They always hire an independent expert. You would think that the person who filed the complaint, who says these bullet points and made the complaint that things were done wrong, should have the opportunity to testify at a hearing and also give me the ability to cross-examine them to see how they determined there was violations, but they never do it. They do not cooperate with the department in regard to the investigation, and you got to dig deep going to the AMC to find out what was really going on here.
And then the AMC is really under no requirement to cooperate. Uh,
Well, if the investigator asks for
right,
a copy,
right.
that they don't need to cooperate with me unless I subpoena them. But and there may be some uh, exceptions to that, but they do cooperate with the investigator. When DPR knocks on their door, they give them everything because
Okay,
they're
all right.
regulated by
All right.
DEP.
Okay. So okay, because they're regulated under Florida statute under
Yeah.
475 Part 2, which is the appraiser statute. Okay.
Right, which
All
gives
right.
the AMC their license to operate as AMC. So
Yeah, and they want to keep their license and keep
yeah, they don't want to be charged with failing to cooperate with an
right.
investigation.
Okay. All right. Now, as we get to the end of this thing, as we wrap this thing up, let's talk a little bit about the appraisal reports themselves. Now, obviously, you get a copy of the appraiser's report and
Mhm.
you read it. Now, you are specifically, as an attorney, you are specifically trained in writing techniques. You'd have to take a class in law school called legal writing.
Right.
Okay. Appraisers don't, and I don't mean legal writing. Appraisers do not take courses in writing appraisals. It
Right.
doesn't happen. So, given the fact that you have to communicate for a living and therefore you're trained in it, appraisers have to communicate for a living, but they're not trained in it. So, do you think that that puts appraisers at a disadvantage, or does that help the appraiser keep things simple and thus understandable?
I think some appraisers get caught up in the boilerplate language and they're just throwing things in the report that are not necessary. And I think sometimes that gets them into trouble, putting too much. But then there's also on the other side, not putting enough information. So they need to find that balance of what really is important to the intended user, because that's what we're always talking about. This report's for the intended user. Is it misleading or is it helpful? And I think they would benefit. And I think there is a course on effective appraisal report writing. They need to focus on that because I think they get caught up and put sometimes just way too much information that gets them into trouble. So they need to learn to focus on the issue. And that's what we learn in law school. Focus on the issue and then go about supporting your arguments.
Okay. Yeah, those classes are out there. Appraisers tend not to take them, however,
Yeah,
because they're long and they're difficult. But
yeah.
no, those classes are out there. Okay. All right. Danny, thank you. I want to thank you, first of all, for representing appraisers. I mean, we don't wake up in the morning and go, let's see, I got to get the dog to the vet. I got to go to the store and I got to screw over a client. That just doesn't happen.
Yeah.
So I appreciate the fact that you're out there for appraisers, helping them out, looking out for their best interest, counseling them, advising them. And, sometimes the counsel you have to give them is, big guy, you screwed up.
Yeah, I mean, I was a prosecutor, and back in the mortgage crisis, we had some bad appraisers. They were reaching value. They were going out there uh, helping facilitate mortgage fraud. I don't see that anymore. All I see are what I call ticky-tack little violations here and there, because in my opinion, there's no such thing as a perfect appraisal report, and they're very subjective. And unfortunately, some people see things one way and some people see the other way. And unfortunately, some appraisal board members see it a certain way and they get the final say because they get to discipline you. But in general, I think all appraisers are trying their best. I just think they're under incredible pressure and sometimes, unfortunately, have to cut corners. And that's when they get caught up with the department, when those corners start being cut and you're missing important things.
Okay. Danny, again, someone needs to get in touch with you. How do they do that?
They're always welcome to call me. I don't charge, consultation fees, anything. I initially do a free interview intake. My phone number is 407-483-0041. And my email is info@frec, F-R-E-C, attorney.com. All one word.
Info@frecattorney.com. Excellent, Danny. Thank you. Please let me thank you for your time, for your
Sure.
expertise.
Tim, I have an
Oh,
interesting question because you had asked me this.
go ahead.
How do you think the new case against NAR, Seltzer case, is going to affect appraisers?
Sitzer Burnett, yeah. Um, Danny, if you go out on YouTube, there are hundreds of videos for
Yeah,
brokers. There are hundreds of videos for managers of brokerage offices.
right.
There isn't very much for
No,
appraisers, which really surprises me, quite frankly. I'm rather surprised that, for example, the Institute has not put out something on this, although it may be. And full disclosure, I'm a member of the Institute. I'm an MAI. Um, but for example, my research has indicated that nobody has answered the question about commissions. Now, Fannie Mae has said, we're not going to worry about commissions. Well, okay, that's the way things were. But here's the problem. The seller pays 3%. Okay, nobody's going to worry about that 3%
right.
commission. But the buyer pays 1% to the buyer's broker. Now, did the buyer try to negotiate the price further down to be able to pay that commission? Or let's look at it from the other direction. The seller says, okay, I'll pay the buyer 1%, uh, just to make sure that the buyer's broker gets paid, but then I'm going to inflate the price by that amount of money.
Right.
so that I net the same amount. Well, is that a sales or financing concession? I think it is. And
Yeah.
I think it has to be adjusted out of the purchase price. But Fannie Mae has not said that, but yet the definition of market value talks about cash equivalency.
Yeah.
So the issue is not resolved. It's not anywhere near resolved. That that a NAR can't require selling brokers to put in a listing broker fee. That's cut and dried. I mean, that's not even an issue.
Right.
The issue is how are appraisers going to treat buyers, brokers, commissions?
Yeah. Yeah.
Not
Because there's going to be
creative?
so
Yeah.
many ways that buyers brokers are going to structure deals.
Yes.
Yeah. There's going to be incredible amount more negotiation on the buyer side. And I was wondering how appraisers are going to, is that going to be analyzed in their opinion of value?
Danny, so far, and again, I'm not trying to pretend I'm an expert on this because I'm not. I've read a lot about it, and I've watched every YouTube on every
Mhm.
video on YouTube from the appraiser standpoint, which is essentially nothing.
Yeah.
And the question is still out there.
Yeah.
And as you indicated earlier, there probably is not a quote unquote right question or right answer to the question. There is the answer you can defend.
Yeah.
So
Yeah.
that's probably what it's going to come down to. But from a black and white, um, clear black and white answer, no, I don't think there is one yet.
Yeah.
There may be, but not right now. As of this recording, which is May of 2024, I don't think there is anything specific yet.
Yeah. It's going to be interesting. We'll see what happens. It's going to be a lot of change in the industry.
All right, Danny, thank you. I appreciate it. I appreciate your time, your
My
effort,
pleasure.
expertise, and the fact that so everybody knows you're so easy to work with. I appreciate that. All right. Um,
Thanks. Thanks, everyone. I appreciate it. Enjoy talking to you guys.